So we're going to get started. So our first panel, of course, protecting artistry, estate planning with copyright. A few notes. I have an incredible attorney with us here today, Mr. Hoffman, Mr. Paul Hoffman. But just so you know, he's not your attorney. This is a very general conversation intended for a general audience. You can hire him. I'm sure he won't object, and we can circulate his information if you're interested in speaking with him. But he's here just to provide some general information. This is not legal advice by any means. You should always check with your own attorney when it comes to estate planning matters. Also, keep in mind that estate planning is very state specific. It's state specific law. So Mr. Hoffman's based in California, so we'll be hearing a little bit more about California law, I'm sure, or from the perspective of I'm sure all the people on the West Coast are very pleased, since we're always talking about East Coast things. So just keep that in mind as well. So who do we have with us? Mr. Paul Gordon Hoffman. He's based in LA. He's a founding member of Hoffman, Saban, and Wanamaker. He is one of the nation's premier law firms devoted exclusively to the practice of all aspects of trust and estate law, including estate and tax planning, dispute resolution, probate, and post-death trust administration. Mr. Hoffman works mostly in the area of tax, estate planning, trust administration, and probate and charitable planning. He was chosen by Best Lawyers in 2010 as the top tax lawyer in the metropolitan Los Angeles area. He was twice recognized as one of the top 100 lawyers in Southern California by Super Lawyers. He is a former chairperson of the tax section of the Beverly Hills Bar Association, a fellow of the American College of Trust and Estates Council. He's taught taxation at UCLA School of Law, and he also taught a course at the USC Law Center. He's spoken on this topic near and far. Also a member of the Motion Picture Television Tax Institute, and is on the planning committee of the USC Trust and Estate Conference. But more than all of this, if I can go off this script for a moment, probably one of the most informed attorneys, trust and estates attorneys that I've ever spoken to when it comes to the topic of copyright. And that is because I believe a lot of his clientele are artists and are musicians. Is something that he's dealing with quite often, which is not often the case for trust and estates lawyers. So I'm just thrilled that he's here today. So welcome, and thank you.
And copyright has its influence on a lot of places. I represent a lot of composers, for example. And there are copyrights there, and motion picture and television, and authors of books. And so, you see copyright popping up in lots of different places.
Yeah. So I guess what I want to start with is sort of a maybe more basic question, which is, why do we really have to focus on this? Why do we have to talk about planning at all? I mean, we have state laws, right, that govern what happens to our property should we die. Why do we have to actually pause and say no? Especially for someone that owns a copyright, it's important to have a plan in place.
Well, the first thing is who's making the decisions, and I think that's the most important thing you can do, especially in a state like California that on the medical decision-making side does not have a default medical decision maker if you can't make decisions for yourself. So at least here in California, anybody over the age of 18 should have an advanced healthcare directive, so that the people who are making not only medical care decisions, but personal care decisions. I mean, what happens if you have a stroke and you don't have to be in the hospital, but you can't take care of yourself? Who's in charge of taking care of you? And the alternative basically is the court system, and that gets expensive and time consuming. If in California, if you're incapacitated, there's something called a conservatorship. In other states, it may be called a guardianship. So somebody has to make decisions for you if you can't make them for yourself. And then when you die, there may be the courts involved with a probate, and that can be time consuming and expensive in terms of legal fees, and as I say, time delays. Uh, and then the other question is, where do you want your assets to go when you pass away? You know, sometimes people will have a spouse or a child, and maybe you want to leave your assets to your spouse, but then you're concerned that, well, what happens if I leave my assets to my spouse and my spouse remarries and the assets wind up going to my spouse's new spouse? So, you know, you may be wanting to create trusts for the benefit of your spouse. The other thing is, how do you avoid family fights? Anybody seen a Disney movie with an evil stepmother, you know, or siblings who can't agree? They've been fighting since they were in the sandbox. So it's important to try to get things set up in a way that avoids family fights. And then you have to know which laws affect you, because you may be living in a particular place, but you may own assets in another state or another country. So, for example, if you're living in a community property state, then half of the assets that you have earned during your marriage belong to your spouse. And even in other states that we call marital property states, your spouse on death or divorce may have a claim to a portion of your assets. And there may be foreign countries involved. In many foreign countries, there's something called a forced heirship that requires part of your assets to go to your kids, and part of your assets may be in what's called a usufruct, where your spouse has certain lifetime rights after which they've got to go to the kids. But again, sometimes you can plan around all of this. Sometimes you can get a prenuptial agreement or a postmarital agreement, or set up your assets in an offshore trust or something like that. So it's important to talk to somebody who knows what they're talking about to get things set up in the way that you want your wishes should control.
And when when we're thinking about our assets in particular, I know there are some assets, they call them the probate assets and the non-probate assets. And is it important to sort of take stock of what would become a probate asset and what isn't? Or maybe we should even define that. Maybe some folks don't know what that term means either.
Well, again, let's start with the fact that some of your assets you may think belong to you, but in fact belong half to your spouse because of the community property laws. And then the way in which you hold title to the assets may affect what happens when you die. So if you have assets held as joint tenants with right of survivorship, that means that when one of the co-owners dies, it automatically goes to the other co-owner, regardless of what your will says or what your trust says. And other people may have assets held as tenants in common. And then when you die, it doesn't automatically go to the co-owner. So it's important that you understand that. Now, some states also allow something called a transfer on death way of holding, or a pay on death holding. And in that case, when you die, that asset will belong to the person that's been designated. You also need to think about things like retirement plans. When you die, who's the beneficiary? It doesn't matter what your will says necessarily. Similarly with life insurance, who's the beneficiary? So you need to find out all of that stuff. But if you have an asset that you own individually and you die, who controls it? Who runs it? You know, if you look at the deed, it says you're the owner. Well, who has the right to control that? Who can sign a deed if you're dead? So there is a court supervised process called probate, and the judge of the probate court will decide, did you leave a valid will? And if so, who gets the assets? And if the judge decides that you didn't leave a valid will, then the judge will appoint an administrator to run your estate. And then the court's order at the end of the day, whether it says, you know, give it in accordance with the will, or it says give it in accordance with the intestate law of our state, that court order is what gives the executor or the administrator the right to run things initially, and decides who gets it at the end of the day. So probate is the default process when you own assets in your own name at your death, and you haven't somehow or other decided by joint tenancy or beneficiary designation or whatever who's going to wind up inheriting it.
So then how do we look at copyright? How does then copyright viewed? Is it something that, sometimes we talk about joint authorship, or owning a copyright, or maybe we could even maybe step back a little bit and talk about the fact that, a little bit about work for hire here too, right? Because you might create a copyright, but may not own it at death. But so how does copyright, just generally intersect in here? Is it something that passes, and to who would it pass?
Well, first of all, a copyright might be community property. There are two decisions, one in California and a Fifth Circuit case involving Louisiana, that say that a copyright can be community property. So, for example, in California, the default rule is that if a person dies without a will, any community property belongs to the surviving spouse. So that may be what happens. But beyond that, if you have a jointly owned copyright, basically each owner of the copyright owns an equal share. And so when you die, maybe your spouse will wind up owning half, and your writing partner will wind up owning half. And then you have all of the problems that you have anytime you've got a co-ownership. Is there some kind of a collaboration agreement that you've got that specifies who's going to get those rights? Now, you were talking about the whole notion of what happens when there are rights as a work for hire. For example, in the motion picture and television industry, generally what will happen is there will be a story by or created by credit, and under the Writers Guild Basic Agreement, those people have certain rights. For example, they would have the right to write a stage play, or they would have novelization rights or sequel rights. So that's all part of the Basic Guild Agreement. But generally, if you just are hired to write something, the copyright resides in the employer, not the person who actually did the work. So this is something that is, generally negotiated at the beginning as to who the owner of the copyright is going to be. And then again, if you've got co-owners, then they each have a share in the rights.
But so if you wrote a screenplay and you actually have those separated rights, and then you die, do those pass then, or should you be planning for what happens with your interest in that?
Well, again, those are difficult questions. And again, I think once you start dealing with separated rights, you really, under the guild, you really not need to talk to your entertainment lawyer and see exactly what's likely to happen. Nice. But the whole issue of characters, is a fascinating one. For example, there have been a couple of Sherlock Holmes movies recently, and that's because the character of Sherlock Holmes is now in the public domain, because those characters are no longer subject to copyright. The very first works fell into the public domain, and so the character of Sherlock Holmes is now publicly available. Not the story itself, but also the character. What I think is going to be really fascinating is Mickey Mouse, because the very first Mickey Mouse film, Steamboat Willie, was released 95 years ago this year. And so you may see similarly people trying to do something with Mickey Mouse now that Steamboat Willie is going to be past the copyright period. So the whole issue of what to do with characters is really fascinating. And what people generally are trying to do with those sorts of things is to control it through trademark or other kinds of rights. But it's an interesting topic.
Let me ask you then, can you, if you're the owner of a copyright, I mean, you had been mentioned before collaboration agreement, can you decide what happens with the copyright through a collaboration agreement, or do you still have to then have an actual estate plan, or can that be done sort of outside the estate
Because generally the collaboration agreement simply says who controls the rights, but who benefits from the rights is a separate issue. And your estate plan is going to control who benefits from the rights. The collaboration agreement generally says who gets to make the decisions.
I see, but in order, you can't like pass a copyright to say your collaborator through a collaboration agreement. That really has to be done through an estate planning tool.
Correct.
Okay. Interesting. So let's talk a little bit about the basic tools. I mean, we know the words will and trust, they get bandied about a bit, but do we need both? Are there things, what are the key terms that we need to be familiar with? What are the key terms we should be asking our attorneys about when it comes to, maybe that's a trust question, since the word will is a single.
Well, okay, so a will simply says, if I happen to own personally an asset at the time of my death, and it's not going to pass through a beneficiary designation, it's not going to pass by joint tenancy, it's not going to pass by a payon death, it's just some in my name alone. The will says who gets the assets. Typically, it would indicate who you're leaving your assets to. But then there has to be a way of making sure that this is your last valid will. It's not a later one. It wasn't. It was done with the appropriate formalities and whatever. And that's what the probate process, again, is all about. But what a lot of people will do is they will set up a trust. It's like a contract, and generally you are your own trustee. You're the administrator of the trust. You run it as long as you're alive and well. If you become incapacitated upon your death, a backup trustee would take over. Now, there are basically two kinds of trusts. There are revocable trusts, which are amendable at will. And then there are irrevocable, non-changeable trusts. And mostly people set up irrevocable trusts during their lifetime because they want to give assets away, but they don't want the person to have absolute control over the assets. So, for example, let's say that you've got a child who's just really bad at managing money. You might want to benefit the child, but you don't want that child to have control of the assets. So you set up a non-changeable trust, put assets in the trust, and direct the trustee, whether it's yourself or some other third person, to run the assets for the benefit of that person, giving them what they need, basically. And this is particularly problematic if you have a child who's developmentally disabled and is getting government benefits, because then you want to set up a special kind of irrevocable trust called a special needs trust that will allow them to continue to get government benefits, even though they have other sorts of benefits. Then if you have a revocable trust, one that you can change, it's revocable, it's amendable. When you die, it becomes irrevocable, non-changeable. So even revocable trusts become irrevocable at some point.
I see. And now to bring back the word copyright and how to best deal with this, perhaps one of the more contentious issues with copyright, right, is and correct me if I'm wrong, if you pass your copyright through a will, it may be subject, it may be subject to copyright reversion. Or no, You tell me. You tell us. Why don't I leave it to the expert? Why am I trying to explain it? You tell us, because I know copyright reversion comes up a lot. It's a big problem with whether or not you can put your copyrights through a trust. Should you do that during your lifetime? Should you never do it? Should you always do it through your will? What's your advice on this? And maybe different attorneys will have different views on it. So you tell us.
Okay, well, so the point is that copyrights don't last forever, as we were talking about. And there are two different sets of laws, one dealing with pre-1978 copyrights and one with 78 later copyrights. So for pre-78 copyrights, the term of protection is 28 years plus, if you renew on time, a 67-year renewal period for a total of 95 years, which is again why Steamboat Willie is so important. Then on the other hand, for those earlier works, sometimes you can get them back through something called a termination of rights after 56 years. For works that were created in 78 and later, the term of protection for an individual is the life of that creator plus 75 years. If you're not an individual, then the term of protection is a flat 95 years. But the thing is, the whole system was designed to deal with the fact that most people who create a very valuable copyright don't know it. I mean, think of all the thousands and thousands of books that are released every year, and how many go on to be bestsellers? How many get made into movies? You know, it's a very small number. And Congress realized that. And they also realized that publishers or other similar folks are in a position to really control the rights. They kind of run the show. So they wanted to give people a second shot. They wanted to give creators of the rights a second shot if it turns out that those rights turn out to be valuable. And so that's called a termination of transfer. So even though you transfer the rights to a copyright to somebody else, you can generally, if you're an individual, you can get those rights back. And you can get the rights back in a period of, it's a window that's between 35 and 40 years after the grant. But on the other hand, you have to give an advance notice to the copyright owner, the person you've sold it to, not less than 2 years nor more than 10 years prior to the effective date. So the effective date's got to be during that 35 to 40-year window. But as a practical matter, the notice has to be given within between years 25, so that would be 10 years before, you know, or 38, you know, so you're not less than 2 years before 40. So that's the window between years 25 and 38 that you give notice. But then once the period ends and you get the rights back, they belong to you, the author. But if the author is dead, then the rights belong half to the author's spouse as determined at the time of the author's death, and half to the author's descendants, if there are any. So you wind up with your spouse owning half and your kids owning half, but if you don't have a spouse, it all belongs to your kids. And those are the people who get the rights back. Now, what does this have to do with a will? There is an exception to the termination rights that says, if you make a transfer by will, then that's not a transfer for purposes of the termination of transfers rights. On the other hand, if you assign your copyright to a trust, that is apparently, law is not real well developed, but this is what it appears to be the law, that it does appear to be a transfer. And so 35 or 40 years, or in that window, however you want to look at it, if you have died, then the rights belong to your spouse and kids, or whoever's around, instead of the way you wanted it to be. So, for example, suppose you wanted your rights to go to charity, not to your kid. Suppose you're not married, you have a kid, and you say, the last thing I want is for my kid to wind up with these rights. Instead, I want it to go to charity. Well, if you leave it to charity under your will, it's going to go to the charity. But if you transfer those rights into a trust, then your kid will get the termination rights if you die, when you die, and be able to get the rights back.
So effectively undoing what you wanted.
What you wanted to go happen with your plan. So it's this termination of transfers business that becomes so important, and the reason why in general you would not want to, if you have a desire to leave your assets in a manner other than, say, half to your spouse and half to your kids, then you need to avoid the termination. Now, sometimes termination actually can be a good thing. If you have a very large estate, and I mean very large estate, you may be subject to estate taxes. Currently, the amount of assets that avoid estate taxes is almost $13 million. And it's going to be going up for the next couple of years, but then it's going to be cut in half. But still, it's a small percentage of the population that has an estate that large. But if you do, then the value of your assets becomes very important. Well, when we value copyrights, we value the projected income flow for the rest of the term. But if there's a termination date and you can't control it beyond that date, then it's not an asset of your estate because you can't control it. Your spouse or your kids do. So sometimes we want to go in the opposite direction. Sometimes our goal is to try to get the rights cut off early to get a low value for estate tax purposes. And then occasionally we will intentionally transfer the assets to a trust during lifetime in order to start the termination rights. So it gets complicated.
I was just thinking that, wait a minute, if you put it into a revocable trust or irrevocable trust, it's going to have a different impact on when that clock starts.
But they are both transfers for purposes of the termination rights. People tend to think that a revocable trust isn't a transfer at all. But it appears that for copyright purposes, it may be.
Oh, wow. Okay. So that's something to keep in mind as well, because you might inadvertently then start the clock on that whole
Right.
copyright reversion issue. So I would say to everyone listening, because I'm sure I'm getting some notes that it's being recorded. Yes, we're recording it. You'll be able to re-listen to everything once we get it edited. But I think also the thing to keep in mind is to make notes and be able to bring these notes to your attorney and ask the question, right? That there is a question you need to be asking here. And, it's not to master it in this 1 hour. I think that that's asking too much of yourself. So just to keep those things in mind. I wanted to turn a little bit towards the topic of selecting executors, selecting trustees, because one of the things you said at the top was who's making decisions. And I mean, this person that you're selecting is following your directions, but potentially also making decisions about your work, right? Your literary work. And do we need a literary executor assigned? Is it enough to have the general executor? Same thing with the trustee. Do we need a special literary trustee? Is the general trustee that we selected enough? With our instruction, if we supply enough instruction, should that person be all right? What's your advice in that area?
So it's oftentimes advisable to leave your literary rights to a literary trust. And oftentimes, we will assign not only copyrights, but the right to control your name and likeness, or to control the characters or whatever. Have all those rights, including the rights to control the overseeing the rights that you've assigned. Suppose that you have assigned your rights to a publisher, and you think the publisher isn't properly accounting for those rights. You may want to do an audit to find out, am I getting all the money I'm supposed to be getting? So you may want to transfer all those sorts of rights to a separate trust. You put your house and you put your cash and stocks and bonds with one person who knows about that sort of stuff, but you put your literary rights with somebody else who really is knowledgeable about literary rights and enforcing literary rights. And then they are able also to coordinate things like licenses. So instead of having to, if you're leaving your assets to a bunch of different people, you have one place, one person who's in charge of all those rights and can grant the rights to make to do a sequel based on your original rights or whatever. Mm-hmm. So it's very useful to set up a literary trust. And then generally what you would say is, not only are the rights part of that trust, but there's enough money that can be kept in the trust to run the trust, to go out and hire an auditor to go out, and enforce the rights, or hire a lawyer to go sue somebody who's infringing, or whatever it is. But if there are excess monies that aren't necessary for that, then hand that money out to the people that you really want to have benefit from it. So it's really an administrative device for controlling your copyrights and your other related rights.
But should this person be then very knowledgeable in the, if you're have a book, should knowledgeable in publishing, or is it enough to provide just the text of the trust document that you're creating?
Well, it depends on the relationship.
Mm-hmm.
And nobody lives forever, so
right.
You're going to have backups as well. But you want somebody who's at least good with coordinating rights among people and following up, and smart enough maybe to hire a good lawyer to help them, or a good accountant to help them. But you want to at least think through the issues and get the person involved, because your spouse may not have any of those abilities and not be really good at running that kind of stuff. And maybe they're fine running some stocks and bonds, but these are technical rights. And, you want to make sure that somebody who's knowledgeable or is smart enough at least to hire good people to do it, they're the person who's in charge. And again, you've got a focal point. Even if the rights are split among a bunch of different folks, you got one person who is in charge of signing off. So that's the benefit of
Is there anything you can do to make sure your authorial intent is upheld? So if you write a song and you never want it to be used, in a car commercial or whatever, for whatever reason, and then of course you hear stories of folks dying and their songs being used for exactly the purposes that they wish didn't ever be used for. Is there a way to enforce that so you maintain your authorial intent?
Well, it's not real clear because you have duties to the beneficiaries, but you can really make it clear in the document what your wishes are. And so you'd have to have somebody really try to challenge it. And then there would be a question about, is this enforceable? There are some people who I've had people say, listen, upon my death, I want my unpublished manuscripts burned.
Right. Yes. I've heard that as well.
And so, there are things that that can be important to people, and you generally can have your wishes enforced. Maybe maybe by law, maybe just by making it clear that this is what you wanted, and get people to respect your wishes.
And I guess what I'm also hearing is an emphasis to remember that there's an ownership, there's sort of decision making that has to happen, and then there's the financial component, and that all of those things can have different names on them, right? So one person might be the owner, another one making decisions about the work, and another person receiving the royalties.
Right. Who the decision maker is and who the beneficiary is can be very different. It's not at all unusual to have a trust, say, with someone your accountant, a bank, a trust company, or whatever, running the trust, but they're running it for the benefit of the beneficiaries.
Mm-hmm.
So one person is deciding what to buy and sell and license and whatever, and somebody else gets the benefits.
Great. I know we're gonna be running out of time if I don't switch to my next topic, which is taxation. Not everybody's favorite topic, but you like it. It seems to be in your wheelhouse. So, it seemed to be, from my understanding, that when we're talking about trust and estates, we're talking about an estate tax, we're talking about an income tax, which is both the income tax that needs to be completed for the person who's passed and for the estate itself. And that we also have a capital gains tax potentially for the person inheriting. Does that sound correct?
Yeah, we got
Okay.
lots of taxes. Lots of taxes. First of all, there are sometimes state taxes to worry about.
Mhm.
Some states have income taxes, other states don't. Some states have state estate taxes, other states don't. So it's important that you know which set of rules apply to you. There is a federal estate tax, as I mentioned. And again, the exemption at the moment is just a shade under $13 million for each spouse.
Mhm.
So that's why in a country where about 3.5 million people will die in a year, there are only about 1,200 to 1,800 people who will die with estates large enough to actually pay $1 of estate tax.
Okay.
So, it's a small group, but for those people, a 40% tax is really significant, 40. And again, if you live in a state like New York, you're paying not only federal taxes, but you're paying state estate taxes on top of that. Or you may have rights in other countries and you may have foreign estate taxes. So you've got all of that. So that's estate taxes. Then there are income taxes. As you mentioned, you're going to have an income tax return for the year of your death. But what about money that comes in the future?
Mhm.
So there are really two different issues. One is when you've got rights coming in, you have royalties, residuals, whatever coming in. What's the impact of that? Well, first of all, for estate tax purposes, we have to value the copyrights. And the way you value the copyrights is you try to figure out how much money is likely to come in over the rest of the term of the copyright, including, by the way, until the termination of transfers kicks in, because then you don't control the rights anymore. So we've got the issue of valuation. Then the second issue is, what about income taxes? Okay, so there are two different sets of rules we need to worry about. One rule says that if I make money and I'm getting paid for the work I did. So for example, again, I work on a film, I write a script, I don't own the copyright, I'm just getting, say, a profit participation or something like that. Even though I pass away, because that's just income that I earned during my lifetime, the people who wind up continuing to get the money pay income tax on that. So they may be subject to both income tax and estate tax on the same amount. So you wind up with something like a 70% tax between estate taxes and income taxes, with the estate tax due right away and the income tax due as and when the money comes in. So you've got that. But on the other hand, if you own an asset, you own a house, you own a car, you own stock in a public company, you own a copyright that you haven't sold, then that asset gets a brand new, what's called income tax basis at your death. Income tax basis is the point from where you figure out whether you have a profit or loss when you go to sell it. So if you, let's just be simple about it. Let's say that there's your house, and you bought your house for $100,000 and now it's worth $1 million. If you sold it the day before your death, you'd have a $900,000 capital gain and have to pay capital gains tax on it. But if you own that house and you die and your executor or your family sells the house, they have $1 million base and they won't have to pay any capital gains tax at all. Similarly, for a copyright, if you have sold a copyright in exchange for rights that are going to be coming in the future, they don't get a stepped up basis because it's income that you've earned. On the other hand, if you've merely licensed it, then you get a stepped up basis. And in that case, you can start depreciating or amortizing, writing off the cost, the value against the future income. And that can, if you've got an estate that's not subject to estate tax, and on the other hand, you got a stepped up basis, instead of paying a lot of capital gains tax, your heirs may be able to pay almost nothing in income tax on the income that comes in, because they can amortize or depreciate the copyrights. So it gets complicated.
That actually, is that something as well? I mean, just to sort of step away from the trust and estates world and keep into the tax world, is that something also that authors could be thinking about during their lifetime then as well? Is the same principles apply?
Absolutely. Are you going to sell a copyright or are you going to license it? And just the words alone are not sufficient. It depends on the term of protection. It depends on the scope of rights that you're selling. If you license all the rights in perpetuity, that's a sale. If you license the rights for 10 years and you get the rights back, and it's only in the US, it's not worldwide, that may be a license. and then you get a stepped up basis. So a lot depends on exactly what your rights are and what you've done.
But if you license for life and you have the right to copyright reversion,
Well, even
is it
so.
for life? I don't know.
So yeah.
Something to discuss, I guess. And then I was reading, and I might be completely wrong about this, but I was reading that music copyrights are always a
Right. So copyrights in musical works are a capital asset. Uh, Even though the general rule is that the creator of a work is going to have ordinary income, Nashville got its way. What can I say? And they got this special rule passed. It's Internal Revenue Code 1221A3. And it says that if you sell a musical work, it's a capital asset. You get capital gains treatment, not ordinary income on the sale.
Huh. Bring all that to your lawyers. So I'm just going to jump to the chat here, give you guys a chance to ask all of your questions. Greg is saying this is a dumb question, but it's not a dumb question because it's a question I definitely think you should know the answer to before you leave today, which is that if you could really define the difference between a trust versus a will.
Sure. So a will is a document that says, when I die, I want my assets to go this way or that way. And so it just kind of sits there and it doesn't affect who the named owner is or anything else. You simply have whatever rights you have. And then when you die, if you have a will and if it's valid and the probate court approves that, yes, indeed, this is a valid will, then it will govern who inherits your assets. But a lot of people will create a separate entity. Think of it as sort of like a separate little company that you set up. And if it was a company, there would be an owner. So who's the owner of the trust? Well, you are. And just like a company might have a president or a managing director or something, the person who runs the trust is the trustee. And again, you generally would be the trustee of a revocable trust as long as you're alive. And then what you would do is you would transfer the assets. So instead of it reading, Deborah Murad as an owner, it would say Deborah Murad, trustee of the Deborah Murad Trust, created October 15, 2023. And then you would make sure that all the assets are registered in that fashion. If you have an asset owned by a trust, then the trustee runs the trust, makes the decisions about buying, selling, licensing, whatever, and handing out the assets. So generally, with a revocable trust, again, you would be both the creator of the trust, the settlor or the trustor. You would also be the person running the trust. You would be the trustee, and you would be the person during your lifetime who benefits from the trust. You would be the beneficiary. So you would be all three things. If you become incapacitated, but you're still alive, you would still be the settlor, the creator of the trust. You would no longer be the trustee. Somebody else would take over running the trust, but you would still be the beneficiary. And then on your death, instead of you being the beneficiary, it would be the people that you've named. Now, if you have a revocable, amendable trust, for almost all purposes, it's disregarded. I say almost. Again, copyright may be an exception, and there may be some other limited exceptions, but generally speaking, if you're alive, the trust is ignored for tax purposes, and it uses your social security number, and you personally report the income. You don't have to file a tax return or anything. Following your death, when the trust becomes irrevocable, non-changeable, it gets its own taxpayer ID number, and it files its own income tax returns. So that's basically the difference. And again, the main reason why folks set up revocable trusts is so that if they become incapacitated, the person they've chosen can take over and run their financial affairs for them without having to go through the court system. And upon a death, their assets can be managed for the benefit of the people they've picked without having to go through the court system.
Somebody else is asking, with regard to trust, then do they offer any other benefits or protections for the copyright or the copyright owner, even against like a claim or a lawsuit? Does it insulate the owner?
It's possible. So if you create an irrevocable, non-changeable trust and you give away the asset, then it may not be available to your creditors. But a lot depends on when the claim arose, when you transferred the asset to the trust, what rights you have in the trust, and things like that. So it's possible, but it just depends.
We have a question about somebody designated their copyright to go to their alma mater. Is that something that they should be speaking with them about beforehand?
Absolutely, because the one thing you always want to make sure of when you're talking about a charity is, do they really want them? You know, we see this all the time with people who leave paintings to museums, and the museum says, we don't want that.
And they can reject that,
that
gift.
Yeah, and even you talk to the current curator who says, oh, I love this kind of stuff.
Right.
And then that curator leaves and another curator comes in and says, ugh. You know? So it's best to talk to the intended beneficiary and make sure that in fact they want them. You know, these days, for example, how many libraries are just dumping books like crazy because they're digitizing them? You know, so you think they would want it. Maybe they do, and maybe they don't.
Right. We have a question here. Somebody, doesn't have a spouse, doesn't have children, and they're looking to put their nieces and nephews. They have many nieces and nephews in charge and to be beneficiaries. And is there any sort of reason not to spread the wealth out when you're talking about your copyright, to let everyone have a piece?
Well, again, who benefits and who's the decision maker can be two very different things. And trying to get everybody on the same page is very difficult. And I've had situations where not only copyrights, but interests in real estate, have been spread out. And the one person who has a 2% interest inevitably says, I'm not willing to deal unless you give me 10%.
Right.
So being the beneficiary and being the decision maker are very different things. And you generally want to centralize decision making in a very small group or one or two people or whatever, even if the benefits are going to flow to a lot of different people.
Got it. And somebody's asking here, relatedly, does the person you choose need to be an attorney?
No.
Is it advisable to have an attorney? I don't know. It might not always be helpful.
No, listen, some lawyers are lousy business people. Okay. Just because you know the law doesn't mean you're a good business person. You want a good business person and a person who's got a sense of people. So if you can find that, they can hire a lawyer.
This is true. So maybe select someone who knows where to find an answer.
Yeah.
would be good. We have one question here. Somebody's saying, so I have a signed notarized trust document. What should I be doing with that document? Does it have to be filed somewhere?
Generally, no, but the people that matter ought to know either what it says, and give them a copy, or at least something happens to me, this is where it is. It's in my safe deposit box, and so has the key to the box and knows how to get in it and is authorized to get in it. Or here's the name of my lawyer. My lawyer has it. Something happens to me, go talk to them. But you generally do not record a trust the way you would file something else. So, for example, if you form a corporation, you have to register with the state, as articles of incorporation. Even like a limited liability company, you have to file articles of organization. There's nothing comparable for a trust.
Gotcha. Okay, great. I think we're almost at the end of our questions and almost at the end of our hour. Would you like to offer a final piece of wisdom? I guess in all your experience dealing with folks and their copyrights, what would you sort of say to the group in a final thought?
Nobody lives forever. Nobody gets out of here alive. So you're gonna go sometime, maybe early, maybe late, but it's best to actually think about these issues and deal with them to avoid having all your money wind up going to lawyers who are fighting with each other or trying to get your wishes determined. Take care of business while you can.
Perfect. Thank you so much, Mr. Hoffman, for being with us for this hour.